My name is Diane Rufino, and my picture of me next to me.
Oh, you can click off that. We can just put the. It might be odd. You're staring at yourself.
I'm Deputy Director of the North Carolina 10th Amendment Center, and it's really my honor and my privilege to talk about nullification. It's something I've been working with for years now, and I feel really very passionate about. So thank you for inviting me and letting me speak, and thank you, Christian, for putting this together.
Could you pull the mic down closer to you?
Yeah, I have to. I don't think it's down any further. Is that okay?
It's better.
Is that better?
Yeah.
Yeah. So the title of today's conference is The Rightful Remedy. We're here to talk about nullification as the rightful remedy to curtail whatever it is that government is doing these days. It certainly doesn't resemble anything that our founders and our framers envisioned. I stand here as an American patriot who is opposed to the unconscionable, unconstitutional usurpation of our God-given rights and liberties and powers reserved to we the people of the states, proclaimed in the Declaration of Independence, acquired by the blood of our founders and revolutionaries, and secured in the U.S. Constitution. I believe that nullification is indeed the rightful remedy to reverse course. Nullification is the doctrine that is based on the theory that the Union is the result of a voluntary compact of sovereign states, and that the federal government, a creature or an agent, has no right to exercise powers not specifically designated or signed to by the U.S. Constitution. Some of you may support nullification, some may not. Some may still be on the fence, and some of you may just not know enough about it. And that's where I come in. I hope I can explain it to you, explain its foundations, tell you some of its early history, and suggest, and really suggest, that this is truly the remedy that we need to focus on. For all of you who support nullification, right up front, let me tell you what we're up against. We're up against politicians who are too timid to stand up to tyranny. We have that problem even in our state legislature. Some of these legislators, maybe even most of them, believe that North Carolina has no right to challenge the actions of the federal government. Some point to the provision in our state constitution, Article 1, Section 5, which demands allegiance to the United States. It reads, "Every citizen of this state owes paramount allegiance to the Constitution and government of the United States, and no law or ordinance of the state, in contravention or subversion thereof, can have binding force." That provision comes from the punitive constitution imposed on North Carolina during Reconstruction. It's unconstitutional, it needs to go, or at least it needs to be rewritten. Other legislators will tell you flat out that because we lost the Civil War, the 10th Amendment is dead, or if it doesn't have much meaning or force anymore. We don't need these brain-dead individuals in office. We're up against those who cry racism the minute nullification is mentioned. They believe that the doctrine is racist, perhaps, or perhaps they just intend to deflect thoughtful discussion on the topic by claiming that nullification was used to further segregation, and therefore it can't be good. As you learned today, nullification was used most effectively in our history to ignore the fugitive slave laws, frustrate authorities who tried to enforce them, and help escaped slaves to live their lives as free men. We're up against those who assert that the Constitution is the supreme law of the land. Apparently, these people believe that everything the government does requires us to bow down and obey, and requires the states to make sure that the federal calls are served. Why even have Article 1 and Articles 2 and 3, which list exactly what the branches of government can do? And why even have the 9th and the 10th Amendments if the government can do whatever it wants? These people have forgotten the key design feature of our government. That's federalism, our most important check in our system of checks and balances. We're up against those who believe that the rightful remedy is at the ballot box. Apparently, they have no problem being oppressed for years by unconstitutional action as they wait for the next election cycle. Government action is hard to undo, as we're learning with Obamacare. I guess I must also believe there should be faith in our voting system. I've just read too many stories about stuffing the ballot boxes and voter fraud to have that kind of faith. We're up against those who believe that the rightful remedy is our federal court system. They actually believe that 9 men and women in black robes are capable of faithfully interpreting the Constitution according to its plain meaning and intent, as explained in great detail in Federalist Papers in the state ratifying conventions, and in the papers of the men who wrote the document. We know they are incapable of it because of such decisions as Roe versus Wade, the healthcare decision by Chief Justice John Roberts, and so many others. We also know they are incapable of it because of a term they're so particularly fond of. The Constitution is a living, breathing document. At least 4 of our Supreme Court justices and most of the federal district court and appellate circuit court judges see the Constitution that way, as a living, breathing document. I wish my mortgage was a living, breathing document. I wish my student loan agreements were living, breathing documents. A living, breathing document is flexible, capable of different interpretations, depending on the year, depending on the judge, depending on the president. A constitution that has no hard and fast meaning can be interpreted however they want. Even as early as 1819, Thomas Jefferson noticed that the Constitution appeared to be a mere thing of wax in the hands of the judiciary, which they twist and shape into any form they please. He said that to consider the judges of the Supreme Court as the ultimate arbiters of constitutional questions would be a dangerous doctrine, which would place us under the despotism of an oligarchy. That was 1820. Jefferson predicted it would be the Supreme Court which would transform our government from one of limited powers to a large central government of concentrated power, destroying the sovereignty of the states little by little. He said, the germ of dissolution of the federal government will be the federal judiciary. They are an irresponsible body, working like gravity day and night to sap little by little the foundations of the Constitution and to change it by construction until we can't recognize it anymore. You know what? I don't think any of these groups that I mentioned are seriously concerned with the proper balance of constitutional power and the long-term security of our liberties. The thing is that we've tried all of these usual remedies, and they really haven't worked. They're not effective as a remedy. We've pressured our representatives. We voted, although we are constrained by the powerful forces that drive political parties. We've taken our chances with the courts, and we faithfully obeyed federal laws. But they haven't done anything to help stop the government from becoming more and more powerful, more intrusive, more controlling, or more arrogant. And finally, we're up against a federal government that desperately wants to keep its concentration of power. So, liberty and freedom. These are 2 terms that we use a lot. We use them to refer to our state of living free, but they don't exactly mean the same thing. Generally speaking, freedom means to be free from something, and liberty means to be free to do something. Again, both refers to the quality of living free. In fact, liberty is defined as being free within society from oppressive restrictions by authority. In other words, liberty is the degree of freedom that we have. Thomas Jefferson's use of the terms almost always reflected these meanings. And I invoke Jefferson because when he wrote the Declaration of Independence, which outlines this nation's understanding of rights and liberties. So Jefferson never spoke of freedom as a right, although liberty is listed in the Declaration as one of our inalienable rights. Life, liberty, and the pursuit of happiness, which most people understand to include the right of property, to acquire property, to enjoy it. Property includes the fruit of our minds, and which we produce, including what we produce and convert into salary, into money. We were expected to enjoy its benefits. These are what our founders believed are inalienable liberties. These are what we can do. We are born with the rights to do these. But what about freedom? What are we free from? The entire context of the Declaration explains what we can be expected to be free from: government oppression. The Declaration doesn't speak much to the limits of freedom because freedom was never understood to allow us to do anything and everything we want. But in one respect, Jefferson was clear: we are to be free from government oppression. And tyranny is another word we use a lot, but we're using a lot more lately. Now, it means oppressive government or rule, the arbitrary use of power, concentrated control of government. Tyranny is the end of individual liberty. It's the death of the soul. It's submission, thought control, total conformity. Freedom and tyranny are at opposite ends of a continuum. They compete for the same space. More of one means less of another. We've heard the quote, when people fear government, that's tyranny. When the government fears people, that's liberty. Finance expert and blogger James Turk wrote, authoritarians and other sociopaths seek one thing above all: control. Some are satisfied just dominating the local PTA, but others want to dominate the world. It's just a matter of degree, but these people exist. And they will do whatever they can to smother the rights of others, which recurs time and time again in history. We have such an authoritarian or sociopath in the White House right now. The tyranny seems to be a word commonly associated with the Obama administration, and rightfully so. Obama doesn't want just to enforce the laws, he wants to make them. Whether he uses his pen and phone or his executive orders, he's attempting to usurp legislative powers that belong to Congress. The most obvious example are his delaying provisions of the health care law, declining to export certain categories of young illegal immigrants, and most recently granting amnesty to illegals and giving them full entitlement benefits. There's one thing that's clear. Obama is engaging in unlawful executive action that exceeds the authority of the executive branch under Article 2, and thus violates the separation of powers principles enshrined in our Constitution. Other examples include making recess appointments, using the IRS to target and silence political opponents, refusing to defend the Defense of Marriage Act, DOMA, in court, frustrating justice with respect to Benghazi, acting as a rogue element on the international stage, and expanding the National Defense Authorization Act, the NDAA, as it pertains to the indefinite detention of American citizens on American soil. The list goes on and on. Every day there's something new from this president. If voters had bothered to look into his background, instead of saying to themselves, gee, wouldn't it be nice for a change to have a president who doesn't look like all the others? Then maybe we would have known about his contempt for the U.S. Constitution. With such contempt, how could we ever expect him to take his oath of office seriously? Constitutions are important. They're important because they set boundaries, reliable boundaries. Most importantly, they set boundaries on government. That's what they're supposed to do. Constitutions are critical because they protect certain rights and freedoms that people can take comfort in, protection in. Recall that Hitler asked for and was granted plenary power with the Enabling Act of 1933. In response to a fire that burned down the Reichstag, conspired and planned by Hitler himself and then blamed on his political opponents, the communists, he demanded to have extreme powers, and he was given them. The Enabling Act gave Chancellor Hitler power to enact laws without involving the Reichstag. That would be like Obama doing whatever he wanted with the country without consulting Congress. Well, that's exactly what he's trying to do, isn't it?
Yep.
Yeah. Immediately, as we know, Hitler began to suspend civil liberties, and the rest is history, death chambers and all. Thomas Jefferson explained, the purpose of a written constitution is to bind up several branches of government by certain laws, which, when they transgress, their acts shall become nullities. You'll notice that Thomas Jefferson defined nullification there. Having a president like Obama in office, using and abusing power when and where he sees fit, and having no real ability to keep him in check, should give us great concern for the future of our republic and for our liberties. There seems to be no effective checks on government, tyranny. Today it's Obama, who will be in office in 2017. What if it isn't a conservative? What if the next president also despises the Constitution? We're dangerously close to the same position the colonists were back in the 1760s and the early 1770s. The current concerns we have today are the concerns they had. We need only go back in history and read what they wrote. Boston lawyer James Otis, the man who gave us the famous phrase, taxation without representation is tyranny, which then became no taxation without representation, once said, "We have always thought it clear that a British subject should be free from all taxes, other than those which he consents to in person or by his representative. This right can be traced to the Magna Carta, is part of the common law, and is part of a British subject's birthright. As such, it is inherent and perpetual as the duty of allegiance, both of which have been brought to these colonies and have been held sacred and supreme. If our charter privileges regarding taxation can be taken away by acts of Parliament, how hard is it to imagine that Parliament can disenfranchise of other rights thought inherent to a British subject?" He was referring to the slippery slope to tyranny. And we're heading down that same slippery slope now, and we're fearful of what the future holds. That slippery slope is what Patrick Henry warned us on the evening of March 23rd, 1775, in the chambers of St. John's Church in Richmond. where the Virginia State Legislature was forced to meet in secret. The topic was the deteriorating relations with Great Britain. Patrick Henry had proposed a resolution for Virginia to raise a militia. While others urged patience with the crown, he believed Virginia needed to begin gathering arms and ammunition and begin organizing a volunteer cavalry or infantry in each county. He spoke very passionately about the need to take such a defensive position. It was his words, his eloquence, which we remember. I have but one lamp by which my feet are guided, and that lamp is experience. I know no way of judging the future but by the past. And judging by the past, I wish to know what there has been in the conduct of the British ministry the last 10 years to justify any hope. Suffer not yourselves be betrayed with a kiss. Let us not deceive ourselves. They send their fleets, they impose martial law. These are the implements of war and subjugation, the last arguments to which kings resort. What can their purpose be other than to force us into submission? We have done everything that can be done to avert the storm which is now coming on. We have petitioned, we have protested, we have supplicated, we have prostrated ourselves before the throne. We have begged the king to interpose on our behalf. We have been ignored, and our protests have produced nothing but additional violence and insults. There is no longer any room for hope. If we wish to be free, if we intend never to abandon that glorious object, then we must fight. They tell us that we are weakened and unable to cope with so formidable an adversary. But when shall we be stronger? Will it be next week or next year? Will it be when we are totally disarmed and when the British Guard is stationed in every house? How shall we be able to resist when we are lying on our backs? How shall we be able to resist when our chains have been forged? Is life so dear or peace so sweet as to be purchased at the price of chains and slavery? I know not what course others may take, but as for me, give me liberty or give me death. Patrick Henry wasn't talking about fighting the British. He was talking about not surrendering precious liberties, that precious gem as he called it. He was talking about a line in the sand, a point beyond which Virginia should not tolerate or submit. The path to our country's independence was paved by a series of audacious acts, inspired by the prospect of individual liberty, not the prospect of enjoying rights generously granted by a king to be revoked at his will or his distemper, but the idea of liberty be vested or belong fundamentally, permanently, securely in the individual, never to be permanently divested or separated from him. And when I went to school, we never learned about the U.S. Constitution or its history. We never studied the words of the Declaration of Independence. We only touched momentarily on the Magna Carta, that first document to proclaim human liberties, the charter that would light the path to liberty in which we ultimately inspire our American Revolution. And that was when I was in grade school. Not a single teacher attempted to connect any dots or put the lessons in any particular context. And it makes sense. That same government which stuffs it down our throat that Abraham Lincoln was our greatest president for saving the Union would certainly not want us to understand that we have the right to stand up and push back against our government. Our children are being taught that it was right for the government to deny states their natural right of self-determination and force them back into submission to a government they didn't want. In contradiction to the words of the Declaration, implicitly our children are being indoctrinated. The most important thing the Declaration of Independence speaks to is the right of a people pursuant to nature's laws and God's law, pursuant to the rights of self-determination and self-preservation, to alter, abolish, and to establish a government that suits them and respects their rights. This is the lesson of the Declaration. Believing that government can abuse us and mandate conformity in order to make us a more permanent union is akin to a husband beating his wife in order to save the marriage. The truth is that our early history, the colonist antagonism to the Stamp Act and the Tea Act and all the intolerable acts, and to the disbanding of colonial assemblies and the imposition of standing armies, and even the premature Declaration of Independence, teaches us about the American spirit, teaches us what the American spirit is all about. It's a rebellious spirit. It's about pushing back against the conduct, but it's conduct that burdens our inalienable natural rights. It's about the willingness to engage in at least simple acts of disobedience to defend what our Creator and nature has endowed us with. The hope is that the spirit still lives. The spirit certainly doesn't belong, it's not in those people that I talked about at the beginning of the talk. The ones who dismiss nullification because it requires too strong of a stand against the government. So the question is whether we're willing to accept nullification as a legitimate remedy against government overreach and government tyranny. Are we willing to support this so-called extreme position? Are we still dedicated to the principle that people have the right to define their government, to set limits on it? Or do we accept the notion, ushered in by Abraham Lincoln, that government has the power to define itself and to seek its own survival and longevity? So let's look at the history of nullification. I'm sorry it took so long for me to get to this point. So first let me review the doctrine with you briefly, although I'm pretty sure you know what it is. The nullification is a remedy based on the separation of powers doctrine stated and defined in the 10th Amendment. Powers reserved to the states versus those specifically delegated to the federal government. The term was articulated by our most influential founders, Thomas Jefferson and James Madison, authors of our two most critical founding documents. Nullification is the foundational principle, the legal theory that states that a state, as a sovereign, has the ability, has the right to nullify or invalidate any federal law that exceeds the scope of authority delegated by the states to the federal government and defined by the Constitution. But here's the important part. Not only does the state have the right to declare a federal law or policy or even court decision to be unconstitutional, it also has a duty to prevent its enforcement on its people. Otherwise, that's tyranny, that's oppression. Nullification is a natural law doctrine. It's based on our federal system, a dual sovereign system, states versus the federal government. Sovereign against sovereign, or to invoke Greek mythology, Titan against Titan, is a doctrine that's brilliantly premised, on the idea that each sovereign will jealously guard its powers and responsibilities and prevent the other from intruding on them. It's like two domineering, hot-headed Italians who are married. Neither wants to concede that the other one has the upper hand. I'm Italian. Nullification comes from the word nullify, verb, or nullity, noun, meaning to be null and void. It means the act of declaring or rendering something null and void. A law made without proper authority is null and void from the very start because it lacks legal foundation. It lacks legal authority. And as such, it's to be without legal force. It's unenforceable, a matter of law. The Constitution implicates two areas of law, compact or contract law and the law of agency. So the Constitution has a compact. Compacts have the character of a contract. They are considered contracts because of the manner in which they are created. In the case of the Constitution, there was an offer to join together with fellow states for mutual benefit, and an option to accept or not. The states accepted in their conventions after considerable debate and discussion. The significance of each convention is how that state understood the meaning and the intent of the Constitution. In contract law, it's the understanding of the parties at the time of the making of the agreement that governs its meaning and its execution. The compact, or the Constitution, enabling the states in their sovereign capacity to act jointly and collectively, each suffering a burden, the surrender of some of its sovereign power, to enjoy a benefit, regular commerce, and collective safety and security. Burdens and benefits are characteristics of contracts. As you all know, the government's not a party to the compact, but merely a creature. As such, it has no independent power or right to alter any terms of that compact. The Constitution is an agent. As you probably also know, the central government was created as an agent to the states. The law of agency, at its most basic, recognizes that an agent can act only pursuant to the consent and control of the principal, or the parties to whom the agent owes the duty. That duty is a fiduciary duty, by the way, one of particular stringency and loyalty. Just as partners in a business firm decide what authority to give their agent, such as the authority to enter into contracts on behalf of the partners, so the parties to the Constitution, the states, decided the powers of the national government. Actions outside the scope of the authority, outside the agency, are not legal, and actions taken by the agent must serve the interests of the partners. Taking these two areas of law together, we can see why Jefferson and Madison understood that each state, as a party to the compact, as a party to over the agent, has an equal right to judge for itself whether the government has overstepped its delegated powers. I'm the mother of 4 children. I have the legal right to determine and to direct the upbringing, education, and care of my children. When my son has a form sent home from school asking permission to go on a trip that might expose him to harm, it's me who has the legal authority to give that permission. Not the school, not the principal, not a neighbor. The reason I give permission, and the reason it's understood as valid, is because I have the legal authority to make that decision on behalf of my son. If someone else gives permission or signs the form, you know what happens. The school won't honor it. My son won't be able to go on the trip. That's nullification. Right? That's nullification. Any act of a governing body or individual outside delegated authority is null from the start. A policeman can't make laws about who should be detained or arrested or have property seized. He can only execute and enforce laws that have been approved by the legislature, a lawmaking body vested with lawmaking powers. If that policeman should try to make law, that law would not be enforceable on citizens. Again, this is nullification. A law without a legal basis is void and unenforceable. The terms, I just got loud there. The terms nullification and interposition were articulated in 1798, following the enactment of the Alien and Sedition Acts during the John Adams administration. But the doctrines were nothing new. Jefferson and Madison merely explained the best and how they should be used to limit government overreach. But prior to that time, the doctrine was something our founders were very familiar with. First of all, we know this from the Philadelphia Convention. Our founders referred to the doctrine by using the term negative. To nullify a piece of legislation was to veto it or to negate it. Furthermore, one only needs to read the Federalist Papers, Federalist number 78, to understand with complete clarity that any law passed by the government that is not pursuant to delegated powers is and should be considered null and void. On the fourth day of the convention in Philadelphia in 1787, Virginia's Governor Edmund Randolph presented the Virginia Plan, which was written by James Madison. Randolph, a polished politician, seemed to have a better chance at selling the plan than mild-mannered, meek James Madison. Madison's idea was to recreate or reform the Union under an entirely different form of government, a Republican model. As we all know, in a republic, the people are the ultimate power, and the people transfer that power to representatives who must act within certain guidelines. Yes, the plan was to form an entirely different form of government, and not merely to amend the Articles of Confederation. Madison believed that the Confederation was given too much emphasis to state sovereignty, and not enough to the national objectives that were deemed necessary enough to establish the national body, the Continental Congress, in the first place. For example, the states were under no obligation to pay their fair share of the national budget, and they regularly failed to do so. They violated international treaties, they violated each other's rights, and in general, they ignored the authority of the Continental Congress. And so Madison originally, because he was a national at the time, he was not a Federalist, sought to establish a dominant central government while curbing the power of the states. To that end, his Virginia plan included these main features: a bicameral legislature, 2 houses, with membership for each to be determined proportional. The lower house would be elected by the people, the upper house would be elected by the lower house. The legislature would be very powerful. There would be an executive, and his position would be enforcement of the laws only. He was to ensure the will of the legislative branch. In fact, he would be chosen by the legislature. There would be a judiciary, with justices allowed to serve for life. The judiciary would have the power to veto legislation, but it would not have the power to be the final voice. It could offer opinion, and then it could be overridden. And finally, the Virginia plan provided that the federal government would have a negative over any act of the states that interferes with the design of the federal government. As Madison's plan provided, whenever the harmony of the United States may be interrupted by any law by any individual state legislature such that it contravenes the opinion of the federal legislature has the power to negative that state law. A negative is nullification, negating that law or declaring to be null and void. But there were some delegates of the conventions who responded that it should be the states that should have that negative against the government, and not vice versa. So you see, the doctrine as applied to government was something very familiar to our founders. In other words, it's a foundational government principle. As you all know, the purpose of the Federalist Papers was to explain the Constitution, to guarantee its meaning to the states so that they can make an informed decision in their conventions. Anti-federalist sentiment was strong at the times, and the states were distrustful of the Constitution that was drafted in Philadelphia. As the author of Federalist Number 78, Alexander Hamilton wrote, "The authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance in all American constitutions, the foundation on which it rests should be discussed. There is no position which depends on clearer principles than that every act of delegated authority which is contrary to the terms of the commission under which it is exercised is void. No legislative act, therefore, contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than the principal, that the servant is above the master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid." So nullification is nothing new. Thanks to Jefferson, we just simply have a cooler name. So how did we get this cool name? Well, when John Adams was elected president in 1796, tensions were restrained between the United States and France. It quickly escalated into a quasi-war, which would last into the 1800s. During the quasi-war, the federal government enacted 4 pieces of legislation that became known as the Alien and Sedition Acts of 1798, the Naturalization Act, the Alien Friends Act, the Alien Enemies Act, and the Sedition Act. The Naturalization Act increased the number of years required for aliens to become U.S. citizens. The Alien Friends Act authorized the President to deport any resident alien considered to be dangerous to the peace and safety of the United States. The administration was afraid of what pro-French sympathizers in the country might do. That act expired in 1800. The Alien Enemies Act authorized the President to apprehend and deport resident aliens if their home countries were at war with the United States, or to subject them to restrictions and restraints if they refused to leave. This act is still good law. It was used to detain Japanese Americans and to confiscate their property in World War II. The Sedition Act made it a crime to write, print, utter, or publish, or assist in such, against the government of the United States, either House of Congress or the President of the United States, with intent to defame them, bring them into contempt, or disrepute, or disturb sedition in the United States. The only official who was not protected was the Vice President, who happened to be Thomas Jefferson. In an administration of all Federalists, Thomas Jefferson was a Republican and a strict constructionist. The act established fines and jail time for anyone who was convicted, and convictions did follow. The Federalists brought suits against the most influential Republican newspapers. Only Republican newspapers, writers, and publishers were targeted. Many honorable men were silenced under the Sedition Act, including those who fought in the War for Independence and one U.S. congressman. Those particularly impacted were political writers and political editors, whose livelihoods were built on the critical analysis of government. They soon learned to hold their tongues and restrain their pens when it came to the government. In other words, they were forced to censor themselves when it came to political speech, the very reason for the First Amendment guarantee of free speech. Look at the particular case of Thomas Cooper, who dared to publish a handbill criticizing John Adams and the government. He was indicted for being a person of wicked and turbulent disposition, designing and intending to defame the president and to bring him into contempt and disrepute. His defense was the truth, which he argued very forcefully in court. He said, "How can people rationally exercise their freedom if perfect freedom of discussion of public characters isn't allowed?" He went further. He said, "I know the King of England can do no wrong, but I didn't know until now that the President of the United States had the same attribute." In the end, he was found guilty and sentenced, fined, and imprisoned for 6 months. Justice Samuel Chase, known for his intolerance of Republicans, was also happy to convict Cooper. At his sentencing, Chase said, I don't want to oppress, but I will restrain you as far as I can. I will restrain all attacks on the government of this country." Though the truth could be used as a defense, the truth is that no one using that defense was ever acquitted. So this is the environment which gave rise to the discussion of nullification as a remedy to put a check on government when it was beginning to overstep its constitutional authority. As you can imagine, the most controversial measure of the Alien and Sedition Acts was the Sedition Act. It immediately sent up constitutional red flags to many of our founders. Thomas Jefferson and James Madison came to the rescue for our Constitution. Thomas Jefferson saw the law as a way to silence any opposition to government at any time, for any reason. He anticipated the parade of horribles, the slippery slope. He wrote to Madison, "I believe the Sedition Act's true aim is the suppression of Republican presses." To many at the time, it seemed the purpose of the bill was to silence political opposition and secure permanent Federalist rule. After all he had done in the cause of liberty, John Adams never questioned the constitutionality of the Sedition Acts. Adams and Congress pointed to elastic clauses, the General Welfare Clause and the No Necessary Profit Clause, as justification to pass these bills. Jefferson, on the other hand, recognized major constitutional violations. He explained that the two Alien Acts would deprive alien persons of their property and their liberty without due process, in violation of the Fifth Amendment. He also asserted that alien friends were under the jurisdiction of the laws of the state in which they resided. That's a 10th Amendment violation. The Sedition Act, he held, were blatant violation of the First Amendment's guarantees of free speech and free press. And finally, Jefferson explained that the Sedition Act was a violation of the 10th Amendment. At the time, there was no 14th Amendment, and so the Bill of Rights only applied to conduct by the federal government. None of the first 10 amendments applied to conduct by the states. And so Jefferson argued that the government had overstepped its authority by inserting itself into this domain reserved to the states. So because of all these constitutional red flags, Jefferson called the Sedition Act a nullity. He said it was a nullity as absolute and palpable as if Congress had ordered us to bow down and worship a golden image. Jefferson pondered what remedies could be taken against this overtly constitutional act, including 1, judicial review, 2, nullification, and 3, secession, which he believed was the state's inherent and natural right, stemming from the principles of self-government and self-determination. All three, he believed, were viable options. He felt secession was extreme, and judicial review was untrustworthy. The Supreme Court at the time was packed with Federalists, and already Jefferson was suspicious of its ability to correctly interpret the Constitution of our founders. But more importantly, Jefferson saw the Supreme Court as part of the problem. For one, it was itself a branch of the federal government, and thus not an impartial arbiter. As he reasoned, the Supreme Court was a branch of an institution which engaged in a power struggle with the states. Secondly, it was comprised of human beings, who, like the rest of mankind, are subject to passions and ambitions, allegiances, whims, and depravities. He concluded that nullification was the rightful remedy. It wasn't as drastic as secession, and it was more reliable than the courts. And he reasoned that nullification by states would prevent things from getting out of hand, it would prevent serious constitutional crises, and it would preserve the understanding of the Constitution at the time, of the time it was ratified. So Jefferson understood that the federal character of the Union was at stake. He understood that national government was claiming powers not delegated by the Constitution. And he feared consolidation. He feared the government would dominate the states and seek to determine the extent of its own powers. He urged that the states must retain as complete authority as possible over their own citizens, rather than bowing to the jurisdiction of the federal government. The answer, he understood, was with the states. The states, though, would have to remain powerful. Jefferson and Madison then began a series of correspondence throughout 1798 over their joint concern over the Alien and Sedition Acts, their discussion over the proper state response, and for the future of the constitutional republic. Jefferson drafted a series of resolutions that addressed several things, including the following. It described the nature of the federal union. 2, it claimed the Alien and Sedition Acts as gross violations of the Constitution. And 3, they described the proper response to be taken by the states. In fact, both men drafted separate resolutions. Jefferson drafted the resolutions on states' rights, which he originally planned to introduce into the North Carolina legislature. But because of timing and setbacks, the North Carolina representative passed it on to a friend in the Kentucky legislature. Kentucky was ripe for protest against the actions of Congress. It would become the Kentucky Resolutions of 1798 and then 1799. James Madison drafted a similar document for the Virginia legislature. They would become the Virginia Resolutions of 1798. Jefferson declared that states had a natural right to oppose federal actions when they found them to be unconstitutional. He stated, "We should be willing to sever ourselves from the Union we value rather than give up the rights of self-government." In the Kentucky Resolutions of 1798, Jefferson opened with these words, "The several states are not united on the principles of unlimited submission to their general government. Rather, by compact, titled the Constitution of the United States, including its amendments, the states constituted a general government for specific purposes, delegating to that government certain definite powers and reserving, each state to itself, the residuary mass of right to their own self-government. And that whenever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. In other words, they are nullities. Without a legal foundation, they cannot be illegally enforced." What Jefferson was really saying is that the 10th Amendment is the foundation of the Constitution. And therefore, when the federal government assumes undelegated powers, it's taking them from the states or from the people. And as such, they are nullities and cannot be legally enforced. When the government takes powers that were not delegated, it has to take them from someplace. He's taking them from the states and he's taking them from you and me. And then he introduced the term nullification. That was in the Kentucky Resolves or Resolutions of 1799. And in those resolves, he wrote that the several states who form the Constitution, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those sovereignties of all unauthorized acts done under color of that instrument is the rightful remedy. Now, the one thing that the Kentucky legislature deleted from Jefferson's draft was the request that each of the coast states, as part of the compact, take measures such that no unconstitutional act of the general government shall be exercised within their territories. So they deleted the interposition part of Jefferson's draft. Jefferson was disappointed at that. The resolutions that he penned were certainly meant to be more than just a mere protest. He shared his disappointment with Madison. In the Virginia Resolutions of 1798, Madison declared that the powers of the federal government are limited by the plain sense and intention of the instrument constituting that compact, and that those powers are valid only as authorized by that compact. He wrote, "In the case of a deliberate, palpable, and dangerous exercise of those powers not granted by that compact, the states who are parties thereof have the right and are duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties pertaining to them." Interpose, to put the state itself between the government and the people for their benefit. Now, Madison did not consider interposition a proper response to every disagreement with the central government, but only when the central government's exercise was deliberate, palpable, and dangerous. On December 24th, 1798, the Virginia legislature adopted the Virginia resolutions. On December 3rd, 1799, the Kentucky legislature adopted the Kentucky resolutions. Only those two states stood up to protest against the unconstitutional action by the federal government. How did the other states respond? Much to their disappointment, Madison and Jefferson received not one favorable response from the 7 states that responded. And the legislatures of the Republican-dominated southern states didn't answer at all. Madison and Jefferson considered them to be timid. So why didn't the other states follow suit? This is what I think. I think that 1790s, which was a very trying time for our fledgling nation, the states had just become independent and faced many hurdles. There was a lot of tension and unrest. I think the states weren't willing to add any additional strain at the time. They didn't want to undermine the Union and give cause for other countries to doubt its legitimacy. And there was something that states probably also considered. And that was the fact that the Sedition Act by statute was set to expire at the end of John Adams' term. And things weren't looking too good for the Federalists at the time, particularly because of the Sedition Act. So the Federalist time would soon be over. And luckily, John Adams was limited to only 1 term. Almost over. The Kentucky and Virginia resolves are very important, and we should be talking about them. For liberty's sake, they highlight something very important. They highlight the grave flaw in the Constitution of 1787. The Constitution does not explicitly provide an umpire to settle disputes between the states and the central government. If the Supreme Court is the ultimate arbiter of the Constitution, as Chief Justice John Marshall proclaimed in Marbury v. Madison, 1803, and then again by a unanimous court, the Warren Court in Cooper v. Aaron in 1958, then the caprice of the national government, and not the Constitution, is the supreme law of the land. Clearly, and we've seen it, if the government is to be the judge of its own powers, it will construe them broadly and dispose of any hopes for a limited government. It was Jefferson and Madison's position that, pursuant to the compact of the nature of the Constitution, in the absence of a delegated umpire, the parties to the compact are the ultimate arbiters of the Constitution. Perhaps a constitutional amendment is needed to end the controversy once and for all. The sad thing is that Jefferson went to his grave under the conviction that the three ruling branches of the national government were acting in combination to strip their colleagues, the states, of all powers reserved to them, and to exercise themselves all functions foreign and domestic. He wrote this in a letter 6 months before he died. Furthermore, Jefferson never supported states' rights for their own sake. He supported states' rights for one primary reason: to safeguard the freedom of individuals, which he understood would without a doubt suffer in a consolidated nation. And that's why, in drafting the Kentucky Resolves, Jefferson identified the states as the proper entities of resistance. And that's why his friend James Madison drafted this Virginia Resolves as he did. There were no men more protected in the Constitution and what it stood for than James Madison and Thomas Jefferson, who wrote the principles on which that document was crafted. And that's why I look to these men for advice. That's why I'm inspired by their resolves. I've written that nullification is doctrine whose time perhaps hasn't come, but I think it finally has. So as you see, nullification is legitimate. It has roots in natural law and in our very founding, and I hope I've made this case to you. William Watkins, a lawyer, wrote, "For true change to take place, Americans must once again conceive of their history as a struggle to create and maintain real freedom. Part of that reconceptualization would entail making a place for the Kentucky and Virginia resolutions in the pantheon of American charters. The resolutions articulate the fundamental principles of our government in an eloquent yet logical manner. In part, they rank second only to the Constitution. For Americans who want to recreate a limited federal government and enumerated powers, the government created by the founders, the resolutions can serve as an enduring inspiration." So we shouldn't forget, and can't forget, that the ultimate goal of nullification is to prevent the enforcement of unconstitutional, oppressive laws on citizens, to prevent the government of usurping powers from those who rightfully belong to, you and me in the states. Thank you.